Okay, thank you. Um, okay, so again, my name's Zeno Lancaster. I'm a native of Asheville, North Carolina. I was born here. We offer a statewide practice for lots of things, for business law, consulting, real estate closings from Asheville to Wilmington and everywhere in between, and the same thing for estate planning. So a lot of these things go hand in hand. People who are buying and selling homes often need estate planning and vice versa. So and and also business consulting. And frankly, a lot of estate planning involves dealing with real estate and businesses. A lot of businesses involves dealing with real estate and estate planning, and vice versa, and all around. So we like to try to accommodate clients with all three. And the truth of the matter is, even though we're here to talk about estate planning today, it's almost always the case that we talk about all of it when we have these conversations and these consults. So my goal for today, and hopefully you guys have this goal as well, is to make sure I'm providing value to you guys on both why estate planning is important, what it really means, because there's a lot of misconceptions about estate planning and how it helps you, how it doesn't help you. When it's helpful, that's a big one that people have misconceptions on. And talk about some of the documents you might need and some of the things you might want to set up and why they're so important. But most importantly, my goal for you guys today is to pull the trigger on this thing. Sorry, I've got a little bug flying around. Pull the trigger on this thing. Most of the people I talk to in estate planning, and I mean most of them, I rarely have a 20-year-old person wanting a will and a trust. Most people come to me and they say, I should have done this years ago. I just had a health scare and I talked to a guy this morning and he said, the reason I'm talking to you today is I spent 7 months in the hospital and almost didn't make it. And if I had passed away, it would have been a disaster for my family, dealing with my assets and that sort of thing. I should have done this years ago. That's literally the quote from him. Most folks come to me and say, I wish I'd done this years ago. I wish I'd had these conversations. And if you guys are anything like me, getting certain things done that's going to benefit you for the rest of your life and behind you, it's a great thing. You get it behind you. You don't have to worry about it anymore. It's going to be there when you need it. You guys have insurance on your houses, your cars, and all sorts of things so that you're protected. This is the same kind of thing. It can be seen as a potential, it's partially an insurance for your assets so that they're protected for your family. It's partially making sure your wishes are followed, not only when you pass, but during your lifetime. And it's a way to show love to your family. You're making sure they're taken care of in the way that most benefits them. And guys, sometimes I know you hear me when I say this, loving your children is not giving them the popsicle. Loving your children is not giving them the second piece of candy that day, maybe, and some of you might have minor children or young children. Part of estate planning is making sure if something were to happen, that they receive benefits from your estate when it's more tactfully given. Certainly you don't want to give a 10-year-old $1 million house. They can't do anything with it on their own anyway for 8 more years, and it's not going to benefit them in any way. But you could set it up to where it does benefit them through a trustee and a trust, for example. Let's say you don't want them to get your assets until they turn 30 or 35. They're a little bit more, they found themselves a little bit more. They're a little bit more secure and settled down. That's something we can also address. So there are lots of different dynamics. And when we get on estate planning consult calls, we really dive into the specifics based on your dynamic. Everyone's family dynamic is different. I have people that, for example, want their spouses to be able to do everything for them with the power of attorney during their lives. I have people that love their spouses, but not a chance. They're not doing anything for them during their lives unless they were to get incapacitated or something. And it's fine. Everybody's got those different dynamics, but there are so many variables on all this stuff. And that's why that estate planning consult is important. So my goal for you guys today is to soak up this information, certainly ask questions, but also look and see when a good time for us to jump on an estate planning call will be for you. Because we can really dive into your situation and tailor something specific for you that's going to help you. You're going to learn as much on that call as you do on this one or more. And again, they're so specific on those family dynamics. This is going to be part of what you need to know. It's not going to be all of it, because it's impossible for me to go over all those dynamics for 20 something people, or how many ever joined this call, in 1 hour, 1 hour and a half time, right? So, okay, man, where to start with asset protection? So estate planning has many different names. Estate planning is one, and people are like, what does that mean? Wills and trusts in estates is another way they put it. Asset protection, you're going to hear a lot of different variations on that. If you Google it and go down that rabbit hole, you're going to spend hours getting as much bad information as you do good. So if you've done that already, and most people have, just know that some of that info is probably correct, and some of it's probably not. And none of it applies to your specific family dynamic, because how could it? Because you haven't explained to whatever on Google you're looking at your specific family dynamic, and that you're in North Carolina, for example. So what I would tell you guys to do is try to take notes during this call. If you have questions that are specific to you, write it down on your notes. And then, of course, we may have time for you to ask it in here, but if nothing else, we can ask it on our estate planning consult, right? So write these questions down that you have. I also may end up answering them. I may end up getting to them. So take notes on your questions that you have, but also take notes on things you hear that might help you in your specific family dynamic, so that, again, we can talk about that at your consult. All right. Okay. So again, I've done estate planning. I paid an attorney, not me, at a different law firm. Put my money where my mouth is, guys. And we got our estate planning done. We did a full estate package. And what I mean by full estate package, again, it's different for everyone, but the majority of the things in there are going to be healthcare documents, power of attorney documents, a catch-all will, and a trust. Now, I know right away there's a couple of you that says, I don't want to hear about a trust. They're expensive. I just want a will. I want a simple will. I understand that sentiment. Nobody likes spending money. None of you would be on the call today, though, if you knew how to do this or knew exactly what best fit for you. And trust me, I've studied a lot of smarter people than I am to try to get to where I'm at with this kind of thing. It's difficult and it's complicated. And your goal, I bet, is for you to make sure you do it correctly. Make sure you do it the way you need to do it for yourself and your family. And we may get on an estate planning consult and decide a trust isn't right for you, that you only need a will and you only need a few things. But most folks I deal with after our estate planning call decide that the full package is what's good for them. It's certainly what I've done. And you want to talk about sleeping well at night on that aspect of my life, I don't worry about it at all. It's really great to have all of that done behind us that fits our specific family dynamic. And when I'm done with this call, you guys are going to understand that any cost that you end up spending on estate planning, whether it's for a few things or the full package, is going to be much cheaper than what it could amount for you down the road if you don't take care of these things. And we'll talk all about that. So if you're worried about costs, the truth of the matter is getting estate planning done correctly is actually going to save you a lot of money in the long run. And I'm going to explain all of that. I will also talk about this, guys. You will find cheaper options. You could Google it right now while you're on this call and find some hilariously cheap option that for a will, trust, whatever. I'm just going to tell you that I also do real estate closings across the state. I do where we have to search and fix estates and all that sort of thing. I see it all the time where a bad form was used. No advice was given with the form. And for example, I'll give you the example now. If you get a trust done, that trust doesn't own anything until you, it's called funding it. That means if you get a trust done, the trust doesn't own your property. It doesn't control your property until you fund it correctly. So just getting the paperwork signed doesn't actually do anything yet. But a lot of those online websites will just spit you out a form trust that doesn't fit your family dynamic in the first place. And it'll have a big waiver at the end that says, we're not a lawyer. Don't sue us if this is wrong. So be really careful with that. And if you've already gone down that road, don't be embarrassed. That's why you're on the call. We can get that fixed and changed. And I can review it, make sure it's correct and fits your family dynamic, or we can just toss it and replace it. Okay. And that applies to wills, any paperwork that you've already had done. And in some cases, it's just been 20 years, 10 years, or your assets have changed, and it's time to look back at that paperwork as well. So you're not only on this call potentially if you need estate planning done, you might be on this call because you want to make sure your estate planning is up to date and that it's correct for your current or changed family dynamic, if that makes sense. Okay. So it's super important to me, for my family, to be secure and have all of that taken care of. And so we certainly got that done, and I don't have to worry about it anymore. I will tell you, if you guys get off this call and say, I'm going to wait, I'll probably wait a month. What's going to happen, because I see it and my clients admit it to me, is that you're going to wait a month and forget all about it, and years will go by. And then something's going to happen, and it's going to be stressful. You're either going to have to rush to get it done. You're going to have to pay more to get it done quickly, most likely. You're going to be scrambling to find a lawyer that can do it on time. And you're going to be stressed out with whatever's going on anyway. And you might not be financially to the place where you need to be to pay for the thing. So I would really encourage you to pull the trigger now, get it behind you. We offer, and I'm going to talk about this later, but we offer different ways to pay. Money should not be the reason you don't get this started. That should never be anyone's reason for not getting their estate planning done. There are lots of options there. Okay. All right. So a lot of complaints I get on, or a lot of, I guess, frustration I get, and a lot of the reason people push back on estate planning. Number one, everything costs money. And it's not the funnest thing to buy. You know, you'd rather buy a boat or a jet ski. I would too. I get it. But what I'll tell you is the third biggest reason people don't love to jump into this, it's a lot of paperwork, and they don't really understand all of it, and they don't really understand what it means. So I'm going to go through some examples of what you're going to see in a general estate, full estate package. Okay. So one aspect you want to worry about is your health care side of things. You know, what does happen if I have a health scare? And guys, we're all human. So at some point, our health is going to be worse than it is right now on this call. You just want to make sure you set certain things up. So there are healthcare powers of attorney. There are HIPAA documents. There are healthcare directives, or what they call a living will. Now, if you feel like you feel yourself glazing over some of that, it sounds like Russian to you. I understand it. I didn't know what it all was when I first started studying this stuff either. What is a living will? The name is very confusing, because it doesn't actually, like a regular will conveys what you die with owning to someone else. A living will doesn't do anything like that. So why it's called that, who knows? But really what these documents do, the healthcare power of attorney is going to allow someone or someone's, maybe someone after them, if they can't do it, yada, yada, to make healthcare decisions for you. So if you're incapacitated, if you're knocked unconscious, if you are sick and they have to put you into an induced coma, there are lots of things that can happen. If you're in surgery, decisions have to be made. This gives your trusted person, your loved one, the ability to help make those decisions for you. A HIPAA document is a healthcare disclosure. So you list on that document, hey, these are the people I hope my doctor, I allow my doctor to share my healthcare information with. They're really not allowed to share much healthcare information with anyone without that document signed. Now, you might have a healthcare power of attorney be 1 or 2 or 3 people, but you might be okay with your doctor sharing it with 10 people, the information that they have for them. And that's something you would fill out and have that in your file for your doctor. A living will is called another name for that is an advance directive. It's saying, hey, if something bad happens to me, I want X, Y, and Z to happen. Now, and it'll work with your healthcare power of attorney. And basically, you'll say, my healthcare power of attorney can make these decisions as long as they don't conflict with these decisions, and they work together. So you might say, my healthcare power of attorney can make decisions on, life-sustaining care, but I want X, Y, and Z to happen, a period. So as long as whatever they think doesn't conflict with these, that's what I want to have happen. Or you can toss the healthcare power of attorney and use all the advance directives you like and not even use that. So these things are very customizable and again, will fit your family dynamic. So other powers of attorney, durable power of attorney. So a healthcare power of attorney deals with everything healthcare related. A durable power of attorney does not. So if you only have that, don't think that you have a power of attorney with your niece and your niece can go into the hospital and make healthcare decisions for you. That is not how it works. So a durable power of attorney sort of deals with everything else as long as it's drafted correctly. So don't pull one off the internet or pull one from another lawyer and say, well, Zeno told me it works for everything. I'm only telling you that if we've talked and I've drafted it. But generally speaking, it works for what you want it to. And most folks allow it to work for everything financially and that sort of thing that they could deal with. But you can limit it. You can say, I want my power of attorney to have the ability to do X, Y, and Z, but not, A, B, and C, right? So you can limit that, but it allows someone else to make your financial and just all decisions for you that you're capable of making while you're alive, if you're not around to do it. And guys, when I say not around to do it, I don't mean that you're in a coma. That can be part of it, but you can also just be traveling. So, you can give your spouse a power of attorney if you need them to be able to sign checks for you or deal with your real estate or whatever. They can have that on hand to run to the bank, use it if you're out of the country, out of the state, and something needs to be done. So it's nice to get into place. And again, different dynamics. Some spouses are fine doing that. Some aren't. Sometimes you give it to your brother or sister or your parents or whatever. So it just gives you an option to have there in place. You can also have it only spring to life when you become incapacitated. So you may not use this power of attorney for 30 years, but it's nice to have that in place should they need it. All right. So a will, all a will does is it says, hey guys, whatever I own personally, when I pass away, I want so-and-so to get it. That's what I want. And you have to administer it through the courts. It doesn't do anything on its own. It's not like in the movies where I don't know why they do this in the movies. A lawyer doesn't show up to your house and say, surprise, you're getting X, Y, and Z. This stuff has to be administered through the courts. Everyone's going to be involved. Everyone's going to be noticed that they're an heir, and you're going to know about that up front. But it has to be administered through the courts. This process takes months, sometimes a year. And it's very expensive. A lot of attorneys will charge a percentage of the total assets. So, for example, if you've got real estate and whatever, bank accounts, retirement funds, all sorts of things, and your total estate is $1 million, okay, which is not all that outlandish with real estate values where they are. It's probably on the low end for many of you. Yes, Monica, I'm talking about a will right now. If they have to probate that estate, a lot of attorneys charge about 5% of that total asset. I know if we've got some realtors in the room, and I believe we do, you guys are quickly calculating what that is because you're used to calculating commissions on $1 million. That's 50 grand. Now I'll tell you, one day I hope to get paid 50 grand for an estate planning project. It ain't today. I wish I could get paid 50 grand for doing your full estate package. So, I'd be doing this Zoom meeting from Bermuda if that was the case, but that's not the case. What a lot of attorneys like me hope you'll do is ignore what I'm going to tell you today about trusts so that you'll have only a will and they get to make 50 grand when your family probates your estate. And so when you think about the costs of doing a full estate package, think about juxtaposing it against if you have $1 million estate or whatever you want to calculate it is. Not many people will die on this call with assets such that their 5% of those will not be a lot more than your cost of doing a full estate planning package today. Okay. And you're going to see those costs here shortly. So if you see me looking around my phone, I've got my screen up behind me, and sometimes I have to look around it to open up a file on my computer. But that's what happens if you only have a will. So a lot of you have wills set up. I know, trust me, no shame in that. You got a will done. That's a good thing. That's not a bad thing. But what the attorney you talked to or the website you used maybe didn't explain to you is that you might actually be better off having a trust. Okay. And it doesn't hurt anything that you've got a will done now. If you have a will done already, it doesn't mean you can't redo it or do a trust. Okay. And I'm getting to why the trusts are so important. Okay. Now, a trust, how is that different from a will? A trust is a living entity. It's just like an LLC. So some of you may have property in an LLC, maybe not. Maybe that's why you're joining this call, to hear a little bit about that as well. A lot of people, for asset protection, will put their real estate and maybe automobiles, whatever, equipment, into an LLC or a trust for asset protection. If someone gets hurt on your property, and I'm Bob Smith, and someone gets hurt on my property and they sue Bob Smith and win, that's a judgment against not only that property, but any property I own under the name Bob Smith. It will be a judgment lien on everything. So a lot of people, generally speaking, right, there are exceptions, but honestly, not a lot, and they don't often apply. So if someone tries to enforce that judgment, they can foreclose on not just the property they got hurt on, they might foreclose on something else I own they like better. Okay. So you want to protect those assets by putting them into a company name or a trust. And this is part of that estate planning consult where we really dive into the specifics with your family dynamic and decide which one's better, right? We may also put your property into an LLC that's owned by the trust. Sort of have a double protection there, where not only are you protected from a different corporate standpoint, but your trust still manages it, which is your total umbrella estate planning dynamic. And so we've got lots of options there. But a lot of the people with multiple properties want to have that as asset protection. And if you don't have it, you are running the risk of opening up a lot of liability on your properties. And you may say, well, that's fine, whatever, I don't care. But think about this. You're really risking your family's properties and your heirs' properties. And that's generally when people are like, all right, fine, I'll protect it. I do want my niece to get it. I do want my spouse to get it. I do want my son to get it. And you know, I don't want someone to get hurt and some judge give them a judgment lien, and you know, then my son's out that property. So that, and it's generally very easy to get put into place. It's just those conversations that we have to have to make sure with your dynamic we get all of that protected. Oops, sorry, stop my camera over. Venus, can you help me read the questions that are coming in, because they pop up and then go away pretty quickly?
Yeah, so Monica asks, can you change the deed on your property and have it under an LLC?
Okay, yes. So Monica, you can. And generally, okay, first of all, yes, you always can. But what we do on these consults is we can talk about whether you have a mortgage on that property. There's something called a due on sale clause that we have to be careful with. But in most cases, we can absolutely do that. In most cases, we can do that even if you have a mortgage on the property. And if we can't, I can walk you through how to get us to that point. So the answer is always yes, eventually. And it's usually yes, we can now. Yep. So Monica, we can jump on that call and talk all about that. Most the people, and I mean maybe 8 or 9 out of 10 who have mortgages on their property who are wanting this done, we're able to do it right away at no big risk to them at all. So quickly, I'll throw this out there just as hopefully added value to you guys. If you have a property in your name and you have a mortgage on it, there's typically a due on sale clause in your mortgage. Again, not always, but typically, especially if it's with an institutional lender. You didn't do seller financing, you got your loan with Wells Fargo or whatever. The due on sale clause typically says if you, the owner, deeds your property to someone else, we have an option. We're not going to automatically. We have an option to call that loan due and payable right away. You have to pay us off immediately. And if you don't, we can foreclose. So it forces people to potentially refinance or sell. And of course, now it's a little scary because a lot of you probably have really great interest rates, and to refinance it, it'd be a huge problem. It'd double your payment or something, right? You wouldn't want to have to do that. So that's why we get on those calls. We make sure you're going to be protected there, and make sure it's not going to be a big problem for you. Again, the same guy I told you about earlier today, he is wanting this exact same thing. He's got an investment property in Lake Lure, North Carolina. He wants to put it into an LLC or a trust, but he's got a 2.85 interest rate on it. I mean, that was great interest rate, right? If he had to refinance, that would be terrible right now where the rates are. And if this is going to be recorded, so right now the rates are somewhere between high sixes, low sevens. So that would be a lot higher than 2.85. So we want to make sure he avoids that due on sell clause. I can tell you from our conversation with him this morning, he's going to be able to. So he's an exception to the due on sell clause because of his situation. And most of the time, that's when I'm talking to folks, that's where they are. And if they're not far away from it, we can get them there. So great question there. All right. So so I think I was talking about trusts, and there are several reasons I really push trust. Now, it's not only me, guys. Trusts are becoming more and more popular in a big way across the nation, not just North Carolina. Most successful people either have or will tell you they should have a trust set up. And there are lots of reasons for that. Number one, you might have privacy concerns. I've had political clients who didn't want their personal name on their house. And, they didn't want their house to get egged, if they made a bad call out in the world, or just a call that aggravated the other half, right? So we put the name in the property into a trust that doesn't have. It's not for example, my trust is not the Zeno Lancaster Trust. It's something else, and so I wasn't all that as much concerned about privacy reasons, but they are protected nevertheless. Why not just knock it out? So when you see my property that my trust owns, you're not going to know that Zeno Lancaster owns it. It's also a little better than with an LLC, because if you own an LLC in your personal name, well, I did that with my LLC. If you guys give me your LLC name, I can open up Secretary of State website in about 2 minutes, maybe 30 seconds, tell you your name, your address, and exactly who owns that LLC. So it doesn't work as well as people thought. I had a seller one time tell me, well, I had a buyer that was wanting to buy in the name of their trust for privacy reasons. And they were really, really very finicky. They didn't want to share financial information, which the seller was wanting to see to accept their contract. And my buyer's like, I don't want them to know who I am. So it's hard for me to give them a bank statement. And I was explaining this to the sellers and seeing what they wanted to do. And they said, oh, don't worry, we understand. We're private people too. That's why we put our property in the name of an LLC. And I opened it up and I said, Bob Smith, manager, Sally Smith, manager. And I said, thanks, Bob. I mean, it was that easy to find out who they were. They didn't do their privacy. They didn't take care of their privacy concerns properly. And it was very easy for me to find out who owned their property, even though they had it in the name of an LLC. So you want to make sure you control that well. And we can, even if you have an LLC, think about it. If the trust owns it, you can't, then they're going to see the trust as owner. They're not going to know who that is. And guys, trust documents are private. It's one of the very few things we deal with in North Carolina and estate planning, real estate business world that aren't recorded publicly. Okay, LLCs are, companies are, your name certainly is. And so a trust isn't publicly provided. Your will is. If you have to get a will probated, everybody's going to go be able. It's public record. They can go pull your administer estate file, and they can see all the information that popped up in that estate administration. They're going to see your bank accounts. They're going to see who got what, and all of that. Completely different with the trust. And to that end, I do want to talk about how a trust helps you avoid probating a will. Let me start with saying a trust is also, I had a client put it this way one time. A trust is a way, while a will only disperses the property you owned when you died to name people. A trust is a way for you to control assets not only when you pass, not only when you pass, but also before you pass and after you pass. So a trust you can name yourself as trustee. That's what most folks do. But the truth of the matter is you can have, especially if you have a lot of assets, you can name a professional as the trustee, and you can tell them how you want their assets dealt with. That's rare, but sometimes it happens with higher, frankly, net worth clients that have a lot of properties. It's almost like they pay this person. It's usually a lawyer, and it can't be me, by the way. So thank you for offering, but it can't be me since I'm doing your estate planning work. But it allows them to manage your estate in the way you see fit. And so some people do it that way, but either way, it allows you to control your assets while you're alive. It designates a successor trustee, or it designates what happens when you pass. And then after you pass, that trustee or that successor trustee continues to manage your property as you direct. So that can be for years after you pass away. So I had a client say, "You mean I can control what happens to my stuff after I die for years?" I'm like, "Yeah, it's as if you're alive, because you're alive sort of through that trust." So that's a big difference in trust and a will. Okay, biggest reason people choose trust, and I do save this for last because it's the best. Yeah, I told you how much $1 million estate would likely cost you roughly to have it administered. And I'm just talking about attorney's fees. I'm not talking about taxes. I'm not talking about anything else that might cause problems. You might have someone dispute the will, dispute the estate. It's going to push it out a year. I'm telling you, it won't just be the 5% that attorney collects if something gets pushed out a year. Okay. And anything else, holding costs on mortgages that have to be paid during that time until you can get that property designated. There's lots of things in there that can add up the cost if you have to administer a will. A trust helps you avoid probate completely. Anything owned by the trust doesn't pass through the estate and probate at all. The successor trustee is told in that same trust you drafted what they're to do upon your death and how they're to manage that property. And frankly, the minute after you pass, they have the ability to do that. They can do with your real estate as they need. They can sign checks for your company. A lot of people who get knocked out, get in trouble, or pass away, if they're a small business owner, they don't want their family having to scramble on how to make payroll. It can shut down businesses if you don't do this correctly. How to pay bills, how to pay a business's mortgage, and that sort of thing. So that successor trustee can do it the minute after, and it makes it super easy. And guess how much that costs when that has to happen? $0. It costs $0 for that successor trustee who now is empowered to make those decisions for your trust. Okay. Now, obviously, you want to pick someone you trust to be this person. That's why it's called a trustee. But they're empowered to do that directly after you pass or whenever you designate. If this happens to me during my life, the successor trustee is empowered to act. If I move to Bermuda, successor trustee is empowered to deal with this because I don't want to deal with it anymore. But I do want it to benefit my niece or whatever it is that your family dynamic wants. So right away, that language, that lesson potentially saved you 50 grand if you get that trust drafted. If you pass with $1 million estate. Most people in this room hope to pass with $1 million estate, wherever they are, at least, right? Truthfully be told, I hope when we all pass, we bought a $200,000 house, I hope it's worth $1 million by then, So you're going to save a lot of money by handling this now. But I'm just going to do a little math for you real quick, and I use a calculator because I'm a lawyer and we don't do math well. Let's say all your assets are only worth $250,000. That's a quarter of what I was talking about. The 5% on that assets is $12,500. I will repeat myself. I wish I was getting $12,500 for your estate planning package today. I hope one day I can charge people that and pay for things a little easier than I do now. But I'm not. That's not what you're going to see in these costs. You're going to save a lot of money, even if you only passed away with $250,000 assets and estate, having this trust in hand and paying for it now and getting it done and out of the way. And you're going to see those cost savings coming up. So that'd be $12,500 out of the pocket of your heirs and into the pocket of an attorney like me who hopes you won't listen to me, by the way.
You have a
Okay.
question.
Yeah.
Gabby asks, can you put your house in a trust if you have a mortgage?
So it's the same discussion as with the LLC. Typically, the answer is yes. We look at it together. And if it's not yes now, it's yes at some point. So we can talk about that. And if it's not yes now, it's yes at some point. And most of the time, it's yes, you can now. So typically, you can do that. We have to structure your trust the correct way for it to fit that exception. But we go through and that in your estate planning consult. I'll gather that information and we can make sure that you're allowed to do that. But generally, most people, because you can eventually, even if they can't, they go ahead and get the trust set up. And then we just, let's say it's another year and then we can do it. We just knock that out a year later and get it put in there. That way it controls everything else they're wanting to get done. And then we transfer that over. But that's rare. Most of the time you can do it immediately. We just have to make sure it fits the rules and the exceptions.
We do have another question.
Yeah.
Does your company accept MetLife legal plan?
So I happily accept any legal plans, but what I will tell you is, in my experience, these legal plans, so if anybody's listening and doesn't know what that means, so some companies companies offer legal plans, and then some companies that you work for as a perk for employment there will give their people membership in a legal plan. And what it typically means is they get reduced and discounted legal fee services from attorneys going through their, for example, a MetLife legal plan. There are others as well. I've tried to get I'll just tell you a story. I had a client come to me about a year ago, wanted estate planning, asked me the same question, and I said, would be happy to do it. And tried to go through their service. A lot of these companies have one attorney's office they use in every state, or one attorney's office they use in every region or whatever. I'd never heard of the company they used in North Carolina. I can't remember this, by the way, was not MetLife. It was a different one. I can't remember who it was. And they said, client, we'll pay for this for you, but you have to use X, Y, and Z law office. And so I told the client that, and he opted to get it done cheaply rather than with me. And by the way, I really think my fees are reasonable, but there's always someone cheaper. You guys remember I mentioned that at the beginning. There's always someone cheaper, and that's up to you. How important do you think this is? Do you want to go the cheap way? Do you want to go my way? So, and that's up to you guys. But to answer your question, I would gladly accept MetLife. Maybe ask them if they have attorney requirements, and some of them don't. Some of them allow you. It's like your medical insurance. You can choose your own doctor, or you can't. You'll just discuss it with them, see if they allow you to choose your own lawyer, and I'm happy to work with them on that. All right.
Like in-house financing too, for people who like have a similar question is like, and he'll go over that, like in-house financing, monthly payments. You basically can go to Zeno and have your call and say, yeah, I do want to do X, Y, and Z, and you both figure out what works best for you. And at the end of the day, like he said, he wants it to be accessible to everyone. So you can come up with a plan designated for you where you can say, I can pay X dollars per month or something like that. You wouldn't get the discount, the painful discount that he's going to offer to everyone here because you're on a long-term payment plan. So you don't quite have as many incentives as people who are going to just pay in full. So that's something to just kind of keep thinking in the back of your mind of the financing and really those flexible payment plans, because ultimately it's going to save you so much money down the road and you really don't want to get caught not having it. So just wanted to insert that here because I think that's kind of around that MetLife conversation.
That's right. Yep. So, and I'm going to talk about the different ways we have to pay. I'm telling you, you guys heard me say this as well too. Money should not prevent you from doing this. And we've tried to offer options to make sure these are very accessible for everyone. And I'm going to talk about that. So if you feel like I'm a little worried about the cost, I don't know that I can come up with it right now, don't jump off the call. We've got several ways to pay, and I'll explain how we've helped certain clients in the past with payment plans, that sort of thing. Okay. All right. So most people have a death plan. If you've had estate planning done at all, you've probably gotten a cheap will off the internet or from an attorney who just said, here's a form will, thinks that'll be $500. Thanks a lot. Bye. Don't call me. Um, and so uh, most people have that death plan in hand. They have no idea. Some of them don't even know what it says. I got it done years ago. I'm not even sure. What I try to help people with is a life plan. You know, part of life is death. And so part of this life plan will be what happens when you pass. But what do you want to happen now? You've got a lot of years left. What do we want to make sure you sleep well at, knowing that's in place now that's going to help your family? That also helps, of course, when you pass. So those are the things we are really trying to hash out. And I've talked a lot about that today, asset protection, that sort of thing. But to summarize, I'm going to go over sort of the main points of that life plan with you to see so you can see how it meshes well together. So again, probate to me is the boogeyman. I am working really hard to be a successful person financially in this life. The last thing I want to do is for my heirs to have to pay 5% to one of my competitors to administer my estate. I don't want that to happen. I want that money to stay with my family. So probate is the boogeyman to me. Typically what we do is we do a trust, and we do a catch-all. We still have a will. We have a catch-all will. And that will is very simple. And it says, if I inherit, $1 million a month before I pass away, and I forget to put it into the name of the trust or into an account that's owned by the trust, or I inherit real estate and I don't put it in the name of my trust, oops, my trust doesn't manage it. My will, now they would have to probate this, but you don't want them probating the entire estate. But my will say, guess where it goes? Into the trust. And so it'll go into that trust, and at least the trust can manage it there going forward. It's a nice thing to have in place. The honest truth is you shouldn't need to use it at all because you remember to put everything in your trust over the years. But in the event you don't, and you don't want your cousin Eddie to get the real estate or the money, it at least flows into the trust so that it follows your plan and your dynamic. And so avoiding probate at all costs, or at least avoiding probate for most of your assets, is so important in my mind, because I just don't really I really don't get it. I really don't get why anyone would prefer probate over a trust. Why would you want a will to go through the probate for months or a year, allow people to dispute it, put it on public display, and cost your heirs 5% of the total? Why would anyone choose that? I don't think, if they're armed with the education, that they will. Not likely, not most of the time. Number two, tax reductions. So I will work with your tax professional and CPA to make sure that we're at least doing whatever we can to minimize tax liability. And sometimes with trusts, you can do that. You can minimize what your heirs are having to pay taxes on. You can minimize what you're having to pay taxes on these various assets, that sort of thing. So there are some tax benefits there. So we can talk through that, work with your CPA, work with your tax professional on that.
Action for CPA, for those of you who are wondering. And we do have some questions. Barbara asked, I have some clients with home safes. Do you have to inventory the safe as well? Thank you.
Now you talk, so by inventory,
like a safe, like,
no,
like a lockbox safe.
Yeah, so yes, by inventorying it, do you have to put it into the trust that's being owned by the trust? Do you mean?
Probably, but Barbara, could you clarify that? I'm assuming that's what she's asking, but I would assume that your catch-all will would be beneficial in that case.
That's right. That's right. That's exactly right. The catch-all will, we can make the trust as well. Say if you have cash on hand at the house, it belongs to the trust. So I do think, guys, if you have cash, a stack of cash at your house, you need to tell someone. Cash doesn't have anyone's name signed to it that owns it, right? So I personally don't keep a lot of cash on hand. I'll get it into a federally insured bank, but that's fine if that's your dynamic. And I do think we should inventory it. And don't do it on a will. Please don't put on public record that you got $1 million in a safe at your house. Let's put it in a trust, if anything, and only the trustee knows about it. Maybe get that into that safe into the hands of a trustee. But that's something we're going to talk about on your estate planning consult, because I'm going to recommend something different. A box of cash at a house, and let's be real, that's what it is just a little risky to me.
Yeah,
If I'm
Barbara said that was her client. So Barbara, when I give everyone the link to book that free consult with Zeno, feel free to grab that link and you can use it for yourself, clients, you can share it like crazy. The other question too was from Gabby. Can you buy a property and put it directly into a trust?
I'm sorry, say that one more time.
Gabby asked, can you buy a property and put it directly into a trust?
Yes. The
You
answer
can
is you
buy
can
the
buy a
property in the
property.
trust name.
Yeah, you can buy a property in the trust name. You can buy a property in an LLC name. Um, I won't stop you. If you're buying with a lender, the lender may or may not care. I've bought properties in an LLC name. I've bought properties in the trust name. I bought properties in my personal name because my lender would not allow me to do differently. So if your lender won't allow, if you have a loan purchase, if you have a cash purchase, no problem. If you have a loan purchase and your lender won't allow it, this is a conversation we can have, because you can absolutely deed it over to the trust or LLC in most cases after the fact. They're not letting you do it at closing because it's their own personal rule. There's no other law or big rule against this. With some of the government loans, they may have a rule against it, but they offer exceptions after closing that we can help get that moved over for you.
Yeah, Barbara was saying it's a larger safe, not a small box, cash, jewelry, etc. items. So yeah, Barbara, I would have your clients book a free call with Zeno to have that further discussion with him.
Yep. Um, any other questions for now?
Yeah, we're about to wrap up. So if you guys want to drop some questions that you feel would be beneficial to the entire group, please drop them there. If you have very specific questions to you, I'm going to put the link to book your free consult with Zeno, so you can go ahead and get that in there. So I'll get that in the chat here in just a moment.
Okay, so asset protection. Another reason people use trusts versus will, remarriage protection. Some people are a little worried if they die and their spouse remarries a bully or a jerk. They don't really want the assets going to the bully or the jerk. They want to make sure those assets benefit their surviving spouse, not their surviving spouse's next spouse, right? So a lot of people use this for remarriage protection, and keeping it in the family. I get a lot of those questions. We have a farm. I don't want it to go to someone who's just going to get rid of it. You can use this a trust to keep something in the family that benefits the family without giving your no count niece or whatever the ability to sell it out of the family if that's not what you want. So it does give you control. And some people are like, that's overbearing, and some people are like, that's what I like to hear. So again, it's your family dynamic that you have there. And then number 4, incapacity. Incapacity happens to all of us at some point. Sometimes it's temporary. Hopefully it's always temporary. You want to have, again, your businesses, if someone needs to sell that real estate to help care for you, hear me on this. Let's say they could sell your investment property, your piece of land that you own, and it would completely pay for your doctor bills, but you can't sell it because you're in a coma. This would allow your successor trustee to take care of that and pay for your care quickly. It's a very good way to cover incapacity problems, and also just allow people to make those decisions while you're incapacitated on all the other things, payroll, that sort of thing. Okay. We do see, and this is why these conversations are good and this life planning is good. We do see 2 problems that do arrive for those that already have some estate planning in place. Their trustee that they name sometimes they don't even know that they're involved. I could be a trustee of one of my brother or sister's trusts and not even know it. They haven't told me. So as far as I know, I'm not, but I see that happen to families sometimes. They don't even know the trust is out there, and people are wondering what happens with their estate. So you have to get these people involved. This is kind of what we talk about in our consults and as we progress on your file, but also how to properly execute it. make sure it's not just a form that someone's handed you for X dollars and it doesn't fit your dynamic. Make sure you, and not only you, but your family members understand what they need to understand and when they need to understand it. I have people that do power of attorneys, and they'll put it in the name of their brother, and they'll say, in a pinch, I want my brother to be able to help, but I don't want him to really do that now, and so I'm not going to tell him, and that's fine. Maybe you keep it for 10 years, and then you say, okay, I'm getting a little older. Here you go, pal. Or maybe you tell your spouse, let him know it's there in case something happens to me and I can't sign. You can let him know it's there, and then he can come in and sign things. But if you never tell him and you never tell anyone else, he may never know about it. So these are the kind of things we make sure of. We talk about where to keep these papers, that sort of thing. A lot of people who already have estate planning done, who are certainly on these calls, they're here because they know it's outdated, or they don't trust that it's not outdated, right? And they need someone to look over it and make sure it still fits their family dynamic. Of course, that's something we can do. We can talk about that at your estate consult. Now, before I start talking about pricing, Venus, do we have any other general questions I can answer?
Monica asked, what happens if you pass and you don't have a will/trust in place? If you have children and if you don't have children?
It's a really good question. So that is what's called intestate. And you've passed intestate. Testate is when you pass with a will. Intestate is when you don't. What I really want for all of you is to pass intestate, but not really. I want you to have a trust and not have a will, but I really do also want you to have a catch-all will. But if you don't have a will at all and you don't have a trust set up, you're passing intestate. And that means the state determines who your heirs are. The state of North Carolina will tell you who you want, who's getting your stuff. And so in my case, I'm getting married in November. I'm not yet married. If I passed intestate, by the way, we've sorted this out. This is not going to happen because we've done our estate planning. But if I had not done any of this estate planning and I passed intestate, my father would own a piece of my law firm, a piece of my house, a piece of everything I own. And I'm just going to let you guys know that wouldn't be ideal for us. So intestate rules are set by the state of North Carolina. It's very easy. This is something I would encourage you guys to Google, and you can see who's going to get your property when you die without all this stuff. And it might help you call me. Let me put it that way, because it might surprise you who the answers are. If you have children, it doesn't just all go to your children. For example, it necessarily. If you're, it depends. If you don't have children, it doesn't all go to your wife necessarily. So make sure you're careful with those intestate laws. A lot of people get them wrong, and frankly, it's the worst way to pass. You should not do something. I mean, that whole point of this call is that you need to be doing estate planning and get that in place so that you know where it's going to go. And by the way, when you pass without a will, it still has to be probated. It still has to go through the clerk's office. You still have to pay 5%. So that also, whether you have a will or not, to establish your heirs without a trust, because again, a trust doesn't have heirs, it's a living entity. To establish your heirs with or without a will, it has to go through the courts. You have to pay those costs. You have to spend that time just like you would with a will. So you want to avoid both just having a will, and you want to avoid not having a will and not having anything else, both. Yep.
Barbara asked, speaking with an attorney assistant yesterday mentioned, which by the way, I don't think that was with our firm, that was someone else probably, in the state of North Carolina, that you could not leave a child out of your will. This was new to me, thank you. So Zeno, can you clarify that?
I don't know anything about that.
Never heard of that before.
Yeah. Now I will tell you, the state of North Carolina does take the best interest of the child in deep consideration on many things. For example, if I say I want my child's guardian to be my sister, if we both pass away, and I put that everywhere in all my estate planning, it doesn't mean my sister is my child's guardian. The court will decide who that is. The court will decide who gets custody. Now, they'll take that into consideration, but they will always do what's in the best interest of the child, and they will be interviewing my sister to make sure that's her. And so the state of North Carolina very much protects minors in so many different ways. A minor, if you deed property into a 10-year-old, they can't turn around and sell it. You'd have to go through the courts, establish a guardian. Again, the court will appoint a guardian. In that case, I guarantee you it won't be a relative. And that guardian will decide whether selling that property is in the best interest of that minor child. So the state really, state of North Carolina really takes that very seriously. I wouldn't be surprised if there's a law against disinheriting a child that's at a certain age or something like that, but I'm not aware of it. So that's something we can look into. But I see it all the time where people say, I have 3 children. One of them's already taken care of, so I'm not leaving anything to them. The other 2 are fine. And again, guys, you don't have to worry about disinheriting a child in a will if you do a trust, because a trust is different. A trust owns the property. A trust operates according to the trust directives for the trustee. It would avoid all of that anyway. So if that's a concern and a problem, you should be doing a trust, which is what I've been preaching this whole time anyway.
Yeah, why would you limit yourself with just a will? If you want to make full decisions and have full control and power over everything, then why would you ever opt to get a will? And even if you just do a quick search in terms of, like, can I leave my child out of a will? The answer is yes, but there's limitations. And like Zeno said, literally every person's situation and dynamic is going to be different. So it's like, why would you put yourself through? And also, Zeno, correct me if I'm wrong, if they have a will and it gets probated, that's going to be public record. So ultimately, wouldn't that cause issues for your family down the road? If, you have 3 siblings and one of them is left out, what if like the person, like you died and you didn't tell your son or daughter, whoever you left out, that they were left out, and then they find out? That might hurt your whole family. Like, there's so many things that you want to keep private, and you have to think about all these different intricate things that you may not think about and just say, oh, I'm just going to do a will. Okay, well, have you thought about this, because all of these other things might happen. So that's another thing to take into consideration as well.
Yeah. Yeah, exactly. I mean, if you don't, certainly if you're, and I have people with different family dynamics. I have people telling me my son is estranged. He doesn't talk to me anymore. It is what it is. I don't like that, but I'm not going to leave him the house. And they leave him out of the everything. Now, usually with me, they're leaving him out as a beneficiary of the trust, but they certainly don't put him in the will. And sometimes that's the way it goes. So yeah.
Is it my Paul? Am I saying that correctly? Asked, can we protect the assets? Can we protect the assets from debtors' judgments with an umbrella insurance instead of putting the assets into LLC or trust?
Well, all you're doing is insuring against getting a law. You're insuring against a loss. So everyone here should have insurance on their real estate and their businesses regardless. I'm not telling you, I'm not telling you how to prevent paying a judgment holder. I'm telling you how to prevent a judgment holder having judgments against all of your assets at once and being able to take one of them. So you should have all of them insured anyway. And we can talk about that as part of our consults. For example, if you have Big Red House LLC and that owns your real estate, and your trust owns Big Red House LLC, Big Red House LLC ought to have some insurance too, just in case something bad happens. I mean, I don't want you to lose. It's not just about protecting your assets, and you might lose one, but at least you won't lose them all. I don't want you to lose any of them. So Big Red House LLC ought to have insurance as well to protect against getting sued and losing. But at least if they do get sued and lose, and it's some sort of insurance exception, by the way, you need to be looking through your insurance commitments and talking to your insurance provider, making sure if this happens, am I covered? That's something else we can talk about. People miss on that all the time. But you want to make sure you're insured on all of these guys. And all, let's say, well, I don't want to do estate planning. I'm just going to keep it all insured for asset protection. That's your call. But just know a judgment lien against one is a judgment lien against all of those properties. And, if you want to get sued and you want to, have all of those properties tied up with a judgment lien so that you can't sell or refinance them for that year-long litigation that your insurance company is going through with you, then do that. but but I would tell you not to lock all your properties up with a potential lien, whether they're insured or not.
Yeah, and the umbrella insurance is not going to take the place of an LLC or trust. You know, it's not like, oh, well, I just have insurance and it covers me. Like, that's not true. So I would definitely look into the LLC or trust option. Barbara said this child, so this is in terms of leaving the child out of the will. This was a child over 18 who was adopted and had drug issues in the past. Large amount of money could be devastating if they received lump sum. Sorry, I was not clear. Also, when dictating the trust slash will, should use percentages of estate and not money amounts. I'm not sure what you mean by that last part, Barbara. You could clarify that, but
Well, I think I know. In other words, she may be saying we don't know what the exact dollar amount is, and if we don't specify, it may not go to the right people. So yeah, you can, if you have cash, especially or bank accounts, you can say I want 50%, whatever's in there, to go to Bob. I want 50% to go to Sally, instead of $100 to each, and there's $100 in there that's not accounted for. I think that might be what she means. All right, so guys, I'm gonna start talking about pricing because we're needing to wrap up a little bit, I believe. So if you didn't get your questions answered, you've got an estate planning consult you should be doing anyway. Bring that there. Okay. So here's the prices. You guys ready for the painful part? I'm going to try to make it as painless as I can. So, first of all, you can reach out to me for a copy of this, especially if you reach out for an estate planning consult. I can send this to you. But we have an estate planning menu of sorts, and it goes over all the pricing that we have typically, generally for the general public. You're going to see on there we have an a la carte menu, or you can buy random one-offs, or you can buy package deals. And my full estate package is the one that includes everything you need, also a catch-all will, also a trust. We have a deal for individuals. We have a better deal for couples. So an individual, if they get the full estate package, they're going to save about $800 off of our a la carte prices. A married couple who, or a couple at all, by the way, any couple who wants a full estate package is going to save a little over twice that, $1,650. Okay. For everyone on the call today, if you book, now I will say real quick, these prices are for the payment plan. So if you decide I want to book it now, but I can't pay in full, we have payment plans, and I'm very flexible on this, guys. Number one, we have legal fee financing. So if you want to go through we've got a wall pay service. It's a national legal fee financing company. It's like anything else you finance. You send them an application. It's really easy. They qualify you, they pay me, and then you make payments to them. That gets your estate planning done right away, and at the discounted pay in full price I'm about to give you. Also paying in full does. You to put that on a credit card or pay with a bank account, whichever one. Now, the payment plans, you are going to pay the prices on the menu. Now, they are already discounted. You're going to see that, but you're not going to get the special pricing today if you do the payment plans, but it allows you to lock it in and get it going. And these payment plans, I'm very flexible about. We can take your total cost, get a payment, monthly payment that works for you. And as soon as we get that, I'll be working on your documents. We'll be gathering information. And as soon as we get that paid off, I'll have everything ready for you. So it allows you to kind of work up to that and get that in the process. That's the biggest problem people have, is just getting this started. Once it gets started, guys, it's easy to get behind you. So if you guys, here's the big savings piece. And I am here to sell estate planning. So it's going to sound a little salesy, but it's a great deal. If you book by 5 p.m. with us on Friday, so you're going to talk with your family. This is already what you're wanting to do. That's why you're on the call. If you book by 5 p.m. on Friday, you've got to reach out to me and let me know to book your estate planning. We get this in process. You're going to save an extra 20% off of the prices you see on this menu. So, for example, right now, a full estate package for an individual, I've got that at $49.50. That's with the discount, the $800 discount. $49.50. Sorry, I'm using a calculator again because I am an attorney and we are notoriously bad at math. So 20% off of that's going to be $39.60. So that's going to be your total for, I'm going to tell you what it includes: a simple will, catch-all will, a trust, a general durable power of attorney, healthcare power of attorney, an advanced directive living will, a HIPAA document. So 6 different things that are going to take care of the majority of your estate planning. Now, some of you are going to want deeds into LLCs and trusts. We'll talk about that. You will get discounted rates on that as well, and I'll go over that with you. But that's for the estate planning piece. For couples, the full estate package, it's $9,400 with that $1,650 savings. You would be paying $7,520. So that's about, a little over $3,500 a piece. For total for your estate planning, that's if you book by 5 p.m. on Friday and are able to either pay in full, credit card, bank account, or through the legal fee financing by 5 p.m. on Friday. And if not, please don't feel too concerned. We'll come up with a payment plan that works for you and make sure we can get this started for you.
Gabby
yes, I can repeat the prices.
Gabby asked, where do you see the payments? Gabby, what do you mean? Like when you submit them, he has different processors that will tell him what's been paid, if that answers that question. But if it doesn't, please let us know. And she also asked, yes, can you repeat the price?
Yeah, sure. So again, now you're going to see this on the menu, and there are lower items you can get, but I'm recommending full estate planning packages because that's what most people need, and that's what most people book with us. So for the people who book by 5 p.m. on Friday, you're going to be able to take 20% off of the prices you see on this menu. So if you need to see the menu, reach out to me. But for the full estate package, for an individual, it's $49.50. But for folks that book by 5 and pay in full through credit card or bank account or legal fee financing, you're only going to actually pay $39.60 for a full estate package for an individual. For a couple, for a full estate package for each of you, you're going to pay $75.20, and that's discounted from $9,400. That's $1,650 in savings plus the additional 20% off. So you're saving thousands of dollars by booking by 5 p.m. on Friday. And that's 20%. It saves you more than 20%, but it saves you 20% off the discounted fee on the menu. Now, if you buy an a la carte item, you're going to pay full price minus 20%, right? And you'll see that on the menu there. But we would certainly love to work with you, love to get this stuff behind you. We always get people who pull the trigger. I appreciate when people pull the trigger. That's why we're offering this extra discount if you pull that trigger 5 p.m. on Friday. Venus, what I miss?
I think you covered most of the things too. So yeah, you get that discount by paying in full. If you want to do a payment plan, there's 2 versions, right? The payment plan is when you say, Zeno, I can pay X amount per month, right? You don't get the discount if that's the route that you choose. If you decide to use our financing, like through that finance company, that will allow you to pay in full. And so you still get that discount if you go through that finance. So what I recommend you do is just use that link, book the call with Zeno. And the thing is you have to, I would book your calls in and get them in by Friday because we have that deadline to pull the trigger by 5 p.m. on Friday. So I recommend if you can't find anything available on his schedule, you should be able to, but if you don't, I will drop his cell phone number in the link, like in the comment section. Just text him and see if he has anything else available, but you should be able to find something for this week so you can get that call scheduled with him.
Yeah, guys, don't stress. But do go ahead and pull the trigger on that estate planning consult scheduling. Get it behind you. If if you're going to do this, don't wait. This is a great discount. We don't do it all the time. We like to do it for the people who jump on the call because, frankly, you're serious about it. You're ready to pull the trigger. We appreciate that. And we know that you guys will talk out and about and hopefully send us some business. That telling them that we did a good job. So we want to do a good job for you, get this taken care of for you. And we hope you guys will take advantage of the savings here.
Mike Paul asks, any additional fee if we have real estate properties and LLCs, etc. So that's a question too. You want to book your call with Zeno to talk about that as well. But Zeno, I'm sure you can elaborate on that a little bit.
Yeah. So sometimes I have people jump on these calls and they want a prenuptial agreement, postnuptial agreement, a deed into their trust. And they may have LLCs and properties in different counties, different states. Yes, some of that's going to involve some additional fees. What I will promise you is if you go through this process before 5 p.m. on Friday, I will also discount those typical fees by 20% for you, whatever they may be. I will tell you deed prep and those sort of things. It's like a typical deed prep, deed consult on something like this is $631 without anything else. So, it'd be 20% off that. 31 is the recording fee. So it's 600 minus 20%. So that's kind of the fees you're looking at. And I'll try my best to put all your properties on one deed for you. But if they're in different counties or different states, that's going to make that impossible. So we'll minimize the cost for you as best we can.
If anyone has any additional questions, feel free to drop them in the comments. We have until 1:30 today. I just want to make sure that if anyone has any remaining questions, we get those answered. Barbara says, thanks for all the information you shared with us today. Awesome. Thanks for coming, everyone. Yes, thank you so much. Awesome. Thanks for coming. Yes. Okay, so I'm not getting any. Brenda, thanks for the information and your time, of course. Great presentation. Thanks, of course. Thank you both so much. Great info. We'll discuss with my husband. We only have an old will. Yeah, Margaret, it would be very beneficial for you and your husband. Just get on that call with Zeno. He's not going to pressure you and push you and all of those things, but ultimately, I would talk it through with your husband and be ready to, at least come up with what that monthly payment would look like for the both of you to make it work. Because ultimately it's going to be really important. Just for reference too, like my personal story with trust and everything is, I got a trust done for my grandparents and they live in Idaho. But I got them a trust a little while back, and my grandfather had a massive stroke the next day after signing the documents. And I was so glad I got the trust done. He had actually survived through that, but he actually recently passed back on like July 9th. So now my grandma is able to get everything taken care of. And her son, who is my uncle, he is there helping her kind of get everything in order because there's a lot going on, like just with like payments and their bank accounts and stuff like that, because she didn't know like how to do any of that. So it's really important that you really make sure, and you don't want to do this when you're, like Zeno, you don't want to wait until it's too late. You don't want to be scrambling. Like I have one, Zeno has one, like all of our family members were like, everyone get a trust, please, because frankly, we also don't want our family having to deal with a hot mess when we pass. So that's something, that why we did it as well too. Ronaldo discussing this with the wife this evening. Amazing. Yeah, Ronaldo, feel free to have your wife on the call with your free consult with Zeno. I think that call will be very beneficial, especially if your wife has any questions. I think that would help too. Gabby, actually, I know this is different, but what is your opinion on gift deeds? Zeno, do you want to share your opinion on gift deeds?
Well, I don't know what's her question about them.
Yeah. Gabby, do you have like maybe a specific question about gift deeds? See what Zeno says. Thank you, Brenda. I appreciate that.
So yeah, gift deed just the gift part of the name just means you're not paying for that sale. You're not buying the property. So most of the time when we convey property into an LLC or a trust, it's a gift deed. Or someone else. Sometimes our estate planning guys is just going ahead and putting property in your son's name. And we do a gift deed and that's like, he's not buying it from you, but you're moving that over into him. And I saw that Gabby responded. What did she say?
She saw another attorney's promoting them. Yeah, so gift deeds are not going to be the full trust though. Gift deeds are not going to accomplish all of the different things that a trust is going to accomplish for you. It's very much just structured towards real estate. And Zeno can tell me if I'm wrong about
Yeah.
that.
And guys, we market gift deeds too. You might have seen me do it.
Yeah.
Sometimes that's helpful. Sometimes that's all. Some of my estate planning clients who've already done estate planning with us need a gift deed a year later. And so, we can also help with those. And again, that's something we can talk about at the call. We have calls on all gift deed consults as well, to talk about due on sell clauses and what exactly we're trying to accomplish, that sort of thing.
Mm-hmm. Brenda, I don't think Zeno heard me when I was like talking mid-sentence, but Brenda, my grandma's name is actually Brenda. So, fun fact. Whenever I see Brenda, like it just like makes me think of her. She's like the sweetest lady ever. She's just a little like angel. She's an angel. Um, any additional questions? Let me grab Zeno's Calendly link just in case it got lost in the chat. And if anyone needs to grab that, they can have that. And then I'll put his cell phone number here too. So feel free to just give him a text too. Like if you use the Calendly link and you can't find anything that works for you, just shoot him a text and he can pull up his calendar and work that over with you. 1493. Yeah. And then I can also send an email with the link as well. But just in case that email gets lost in like your spam folder or something, I would just grab this link. So that way you have it. Okay, any other questions? We have 10 minutes remaining, but I feel like we're good to start wrapping things up for everyone. Thank you everyone so much for being here. We really hope that you have found value in this. Really our mission is to make sure that you and your family is protected. At the end of the day, you're going to be protected, and I can say literally from my own experience, just within the past week, it's been extremely devastating and hard and emotional for my family. I can't imagine being devastated and grieving a very hard loss of a family member. I can't imagine also like scrambling and not having a trust in place. Like I am so grateful that I got them a trust because my family is already a hot mess right now. And if they didn't have that, I don't know what we would do. I think it would just be absolutely awful. It would make the process so much worse than it already is. You know, on top of grieving, you're also having, we'd have to go through all of these other things. We're still having to, of course, go through the cremation and like all these the celebration of life ceremony and all these things, right? But we're not having to worry about probate and like all that other crap. And my grandma can just go and she can and her son, my uncle can just go with her, get everything settled, the bank accounts, the bills paid, like everything is seamless and easy because all they have to do is go to the bank and show them that document. And they don't even need to do that now because my grandma is still on the trust and she's still living, right? But it even just allows people to help her because she can't do it on her own, so that's important too. At least for my family specifically, that was something that was important for us. So all of these different things you have to kind of think about, even if it's not fun to think about, honestly, it's not fun to think about or talk about, but having to go through a probate would be just so much worse. And I'm so grateful that we don't have to do that. So Zeno and I's goal is so that we would love everyone in the state of North Carolina, because that's where he practices. He practices statewide. He gets on calls with clients that are all across North Carolina and helps protect them and their families. And he makes it very accessible, which I think is so important because I really hope that my hope and my prayer for everyone and wish is that you can go to bed at night, you can sleep at night knowing your family is safe, and you don't ever have to go through the gut-wrenching probate system or lawsuits or any of those things. It's just you can go through your process and go on with your day. So that's our goal for everyone today. So you just feel like you can be protected, but you don't feel like money is going to be that barrier, because that's to us, that's our worst nightmare, is someone didn't do their estate planning because of money. Like that's a nightmare because probate's going to be so much worse. So I hope that helps, even just me kind of sharing like that personal experience because my family's going through it right now. Monica, please send the recording if possible to our emails. Would love to send it to a friend who has will. Yeah, absolutely, Monica. I will. It's going to be saved to the cloud, so once it like processes and everything, I will get it into the Facebook group, get it into a link. I'll put it on the YouTube as well. Zeno has a YouTube channel, so I'll put it on that YouTube channel, and you can share the link, and people can watch it from there. Gabby asked how long is the process? So it's normally where, and Zeno can elaborate on this, but you get on your call with Zeno, he asks you a series of questions. and then he creates the documents for you, and then you sign them. Pretty like simple and easy. Of course, like the actual call is a lot more in depth, and that's that process. But ultimately, it's not like you have to jump through a bajillion hoops. It's, it's probate, probate and all the other things are a lot harder, a lot more expensive and time consuming and everything like that. So in my experience, when Zeno and I got our trusts, I mean, it's very quick and painless. Like you get on your call, tell them what you need. They, Zeno's going to draft the documents, you work out your payment plan, and you go on with your life. Okay, any other questions we feel, Gabby? Yeah, of course. Yeah, of course, Monica. Okay, well, thank you everyone so much for, yeah, of course, Cecilia, thanks for coming. Thank you again to everyone who's here, and we hope that you found this beneficial. And if you have any additional questions, feel free to book your call with Zeno. And we also have a free Facebook group as well. Let me grab that link for everyone just so you have it. It's the State Planning North Carolina one. That's going to be a good one for you to join as well if you are on Facebook like we are. We also have an Instagram and stuff like that too, but that estate planning group is a good one to join. Okay. All right. Zeno, I think your internet is cutting out a little bit, so like you're getting super choppy. So we're gonna end the call here. Thanks everyone so much for being here. We really appreciate you, and we will talk to you very soon. Bye.